Hello, my name is Jasmine Kooner, and I'm a lawyer at Priddle Law Group in Kamloops. I'm on the board of directors of the TRU Alumni Association, as well as an alumni of the Bachelor of Business Administration program at TRU. Today, I will be giving a short presentation about estate planning, specifically focusing on 3 important documents that everybody should consider having as part of their estate plan. I will be discussing wills, powers of attorney, and representation agreements. Due to time constraints, the presentation will provide a high-level overview of each of these estate planning documents to give you an idea about what each of the documents is used for. I do want to note that I am not providing legal advice. I'm only providing legal information. It's very important that you seek legal advice that is specific to your individual circumstances from a lawyer or a notary who practices in the area of estate planning. Everyone will have a unique estate plan based on their individual needs. During this presentation, I will not be addressing medically assisted dying or taxation issues. I'm first going to start off by discussing wills. So what happens if you die without a will? If you die without a will, it's called dying intestate. And if you die intestate, there's added time and paperwork for your loved ones, which equals added costs. There also is not an administrator that's entitled to act on behalf of your estate. So your accounts can be frozen without communication to your loved ones. And there's also possibility for beneficiary disputes because your wishes weren't made clear. As well, anyone can apply for the administration of your estate, and it might end up being someone that you wouldn't have chosen. That also gives that person access to your assets. Now, I have a slide up here that discusses, it kind of goes over who your assets will go to if you do not have a will stating who you want them to go to. It kind of lists out in order, the order of importance as the legislators have decided who your estate should go to. Now, if you look at that, that might not actually reflect what your wishes are, and you might not want your assets to go to those people in that order, which is another reason why it's very important to have a will stating your wishes. Also, as well, if this whole list is gone through and you don't have any of those family members living, then at the end of the day, your estate will go to the government, which might not be what you want, most likely not what you want. So that's another reason why it is very important to state your wishes in your will. So what does a will do? A will deals with distributing your estate assets after you pass away. It also, you would deal with in your will naming an executor or possibly alternate executors if your chosen person can't act. That's the person who deals with administering your estate assets after you pass away and distributes them according to what your wishes are. It also provides clarity. Providing a will or preparing a will before you pass away will help avoid leaving a mess for your loved ones to deal with after you're gone. Wills are especially important in situations where there's unmarried couples, blended families, estranged family members. Anywhere where it's not a traditional family structure, you especially want to make sure that you have clarity of how you want your estate assets to be distributed. And it'll also save your beneficiaries time and money. So, what information do you need to make a will? Things that you have to think about before making a will are, what are all of your assets and your debts? You need to know that in order to make a will. Also, when you're preparing to go in to see your legal advisor, thinking about who makes up your family tree so that your advisor can give you advice on contingency plans if the chosen beneficiary that you want to name passes before you. Where will your assets go if that person has passed away? As well, the full legal names of anyone who is to be named in the will. Thinking about any estranged family members, anyone who's predeceased you, in terms of close family members. If anyone goes by an AKA, which is an also known as, so that they can be properly identified in the will if they don't go by their legal name. if you have a spouse, and basically telling your legal advisor about any secrets so that your legal advisor can properly advise you on your estate plan and what different consequences could arise if you do certain things in your will. As well, you do have to have mental capacity to make a will, of course, and if that's in question, there will be specific questions asked to make sure that you do have that mental capacity to make a will. And then finally, what do you want to do with your estate assets? When you go in to see a lawyer or notary, there's things that they're going to consider. So again, like I said, capacity. It's important to note that legal capacity is different than medical capacity. So your legal advisor might be asking questions that perhaps a doctor would not be asking. It's a different threshold. Also, whether there's any undue influence or duress. Is somebody pressuring this person to make their will the way they're stating that they want it to be made? Or are they making this will of their own free will, which is obviously important. There's many more considerations when making a will, and there's a number of legalities surrounding drafting a will, which is why it's so important to obtain legal advice. So just a few of those considerations are listed on the slide here. And of course, you'd have to get further advice on those, but those are just things to get you thinking. So there are certain requirements, so validity of a will. There's certain requirements about how a will has to be signed, witnessed. Are there gifts made to witnesses of the will? Because that's not allowed either, which is why you want to make sure that you've followed all the steps to make sure your will is valid and all the gifts are valid. Making gifts to former spouses, proper identification of the beneficiaries, executor remuneration. So it's also important to note that executors by law can be compensated if they choose to ask for that for the work that they put into administering the estate. And you can put in a specific clause in your will if you want to make sure that they do compensate themselves. But even if you don't do that, you do have to be aware that they are entitled to compensation. Guardianship of minor children is an important thing to think about. If you're going to be disinheriting anyone, you do also have to know about the consequences or what that disinherited person, what actions they can take and what legal remedies they have. What happens if one of your beneficiaries passes away and they're named in the will, and if there isn't an alternate? And finally, what happens if you, if you no longer own a specific item at your death? As well as executors' duties and powers. So those are just a few. It's not an exhaustive list, but it's just a few considerations that you have to think about when you are preparing a will. Another thing is, do you need trusts in your will, trust provisions? So just a couple of examples are trusts where you might not want someone's inheritance to go to them all at once. You may, for example, if you have a child, you may want a portion of their inheritance to go to them when they're the age of 19, but some of their inheritance to also go to them when they're 22 and 25, so that they're not getting a huge lump sum of money at the age of 19. That's something that you can get advice on. As well as, do you have somebody who's disabled that you want to provide for? There's a lot of considerations that need to be taken into account, such as, do they get a disability pension? You want to make sure that getting a lump sum of money isn't going to preclude them from getting government benefits. So oftentimes that's dealt with by way of a trust in the will. There's also other discretionary trusts that can be in a will, and trust provisions for minors, as children cannot inherit their inheritance until they reach the age of majority, which right now in British Columbia is the age of 19. These are all things that your legal advisor can assess and advise on for you so that your estate plan works best for you and your family. Now, there's some items that don't form part of your estate, and I've said in the slide that that's usually because, again, each person's circumstances need to be assessed, but typically insurance policies, investments with beneficiary designations such as RRSPs, RIFs, TFSAs, those usually, if you have a proper beneficiary designated will flow outside of the will, as well as pension plans and property that's held in joint ownership. So another thing that you need to do when you're speaking with your legal advisor is just talking to your other advisors. So for example, your insurance agent, investment advisors, finding out how you hold all of these items and how they're going to be dealt with once you pass away. Again, due to time constraints, I'm only briefly bringing these items up and they have to be discussed in detail. With joint ownership, that's one that's really important, and there's many legal and tax consequences that can arise out of holding property in joint ownership. So that, again, is something that you need to get advice on that is specific to your circumstance. So that was my brief overview of wills. I'm now going to move over to representation agreements. So representation agreements are documents that deal with your health and personal care while you're living. And so you appoint somebody who is able to assist you. So essentially, that representative has authority over your medical decisions and your personal care, and they can assist you when you're able to do some things on your own, or they can act on your behalf when you're incapable. By appointing someone as your representative and preparing a representation agreement, it gives you autonomy and dignity because you are making the choice of who is going to help you with those decisions. There are two different types of representation agreements. There's a Section 7 representation agreement and a Section 9 representation agreement. The Section 7 representation agreement is more limited than a Section 9 agreement. And one of the differences is that it doesn't allow the representative to make a decision regarding admission into a care facility. As well, someone who has the power under Section 9 has the authority to refuse life-supporting health care. Section 7 representation agreements are typically used when an adult is making the agreement when they don't have the full legal capacity to make a Section 9 agreement, because there is a higher threshold for capacity for making one of those agreements. So I have a slide here that just kind of gives you an idea of what do we mean by personal care? So personal care can mean a number of things. And again, this is not an exhaustive list, but for example, your representative would be able to help make decisions regarding shelter or living arrangements, assessment and planning for support or services, arranging and managing support or services, including hiring staff who are paid privately to provide care. So for example, having a nurse come into your home and provide care for you. Diet preferences, exercise, spiritual matters, care of pets, personal safety and contact with others, and participation in activities. So what happens if you don't have a representation agreement? Well, if you don't have a representation agreement and you don't have the ability to make healthcare decisions and personal care decisions on your own because you no longer have the capacity, then decisions can be made on your behalf by a healthcare provider. And those decisions might not reflect your wishes or values because that healthcare provider might not know you or have any idea of what you would have wanted for yourself. Or they could take instructions from someone who you don't want making those decisions for you. Again, there is a list that's in legislation that goes through a list of who they have to consult first, and it is family members. Typically is what that's where it starts, asking, for example, first person, a spouse. But that, again, might not be who you want making decisions for you. And again, it is more complicated in a situation of if you have a blended family. And finally, I'm going to touch on the last document that I'm going to briefly cover, and that's a power of attorney. So a power of attorney is another document that assists with when you're living. So you're appointing an attorney, a representative essentially, who is able to make help you with your finances and legal matters. And again, it's for when you're living. So The benefits of a power of attorney are that your attorney can deal with real estate and personal property and make decisions about your finances and conduct legal matters on your behalf. In terms of asset management, they can deal with your bank accounts, investments, your real property, so the ability to acquire, sell, transfer property on the adult's behalf, pay bills, taxes, property expenses, renew insurance, access information from CRA with respect to your tax return. In terms of legal things that they're allowed to do, they can initiate or defend actions, settle debts, deal with contractual matters. Powers of attorney usually have a broad authority, but you can limit it to specific things that you want your attorney to be able to do. It can be very specific. It can be as specific as, I want my attorney to be able to deal with this property located at this address. So again, completely up to you depending on what your circumstance is and the circumstance of why you're getting the document drawn up. An enduring power of attorney is what is most commonly drafted in my experience, and it is a document that's effective while you're capable. With your consent, your attorney can act, but it continues even when you're incapacitated. So what happens if you don't have a power of attorney and you no longer have capacity to make your own decisions? If that time comes, then someone has to formally apply for a committeeship, and that is a rigorous process that can be very expensive. So just a few of the steps that person would have to take is they would have to get 2 letters from medical professionals that outline your capacity or lack thereof. The public guardian and trustee has to get involved, and ultimately the court decides on a public application who gets to make decisions on your behalf. This again takes away your autonomy to choose, and it's also a very expensive process. And it's significantly more time consuming and expensive than getting a power of attorney drafted. One last thing that I just want to cover, I know this was, again, a very brief overview of everything, so it's just kind of to get everybody thinking about these different documents so they have an idea of what each of them are. But again, I'm going to stress that there's a lot more to each of these documents, and you definitely have to get advice on them. I do want to address that this presentation is being aired during a time where social distancing is being recommended due to COVID-19. A lot of people are worried that law firms are closed or lawyers aren't meeting with anyone, and it's during a time where people actually are considering, powers of attorney, representation agreements, or wills just because of the circumstances. I just want to assure everyone that there are many lawyers that are still working, even if it's remotely. And if you want advice on any of these documents, please reach out to someone. A lot of lawyers right now are still able to meet with clients, take their instructions, advise them, and then prepare documents, and either they will witness the documents for the client, or they'll give detailed instructions on how the documents must be witnessed. Lawyers are an essential service, so they are able to still operate during this time, and things right now might look a little bit different. The consultations might take place over video conferencing or telephone, where typically you would go into the lawyer's or notary's office. But I just do want to assure you that you should not hesitate to reach out and ask how services are now being provided. Thank you very much for your time. I hope that this presentation was informative, and I hope that it assists you with any of your, giving you some information about your estate planning needs. Thank you very much.